YouTube, it's Tone, back with another one for you. Now, this one here is a continuation of the common law abatement book. This book is fucking fire. You guys need this shit. You need this shit. Alright? Stop fucking fighting with these people. Using corny ass methods or using the methods that they want you to use. They're not gonna tell you what all your options are. They're gonna tell you what the options that they offer are. And they're usually corny as fuck. And they're usually to their benefit. So we'll get right into this. This is another affidavit. This book is full of affidavits, so you should definitely grab it, use it as a template to put your shit together. Keep in mind too, this is for United States District Court, so this is all in federal court. Nobody gives a fuck what these states are talking about. They're all subject to the federal courts, all right, because they take money from them, they contracted with them, they're registered to the states, which are all fucking registered corporations, which is gonna make them a subject to them. As much as they like to act like they can make their own fucking rules, they cannot make their own fucking rules. And these people have no standing in federal court. They're regular ass clowns, just like I look at them. That's how the judges in the fucking federal courts look at them. Alright? So they can say whatever they want and it's all fun and games until they're standing in front of a fucking Supreme Court justice. And then you'll see who these fucking clowns really are. Nobodies. Bunch of nobodies. So, here it says, defendant notice to abate and memorandum of law in support of, and then so this proceeds to go into the reason why, the supporting information behind this affidavit. Right, so defendant, your name, files this notice to abate plaintiff suit, which is so the state's going to be the plaintiff. And don't ask me how the fuck the state's the plaintiff when the state is a fucking fictional character to begin with. Who the fuck's pressing the charge for the state when the state's not even real? Cut it out. So file this notice to abate plaintiff suit for lack of subject matter jurisdiction as authorized by Federal Rule of Civil Procedure 12B1. Defendant asks the court to take judicial notice of the fact that he appears without assistance of counsel, is not schooled in the law and legal procedures, and is not licensed to practice law. Therefore, his pleadings must be read and construed liberally. See Haynes versus Kerner. Right. So further, defendant believes that this court has a responsibility and legal duty to protect any and all of the accused's constitutional and statutory rights. Right. And so it proceeds here to go into the different case law associated with this claim here. Or supporting evidence here. And you can look up these case laws to go ahead and verify that as well. So, a introduction. The United States of America is the plaintiff. Your full name is the defendant. Plaintiff sued defendant for whatever the fuck that they're supposedly suing you for. Because, I mean, keep in mind that, all of these charges are really just a claim in equity disguised as a criminal charge. You know what I'm saying? These motherfuckers are literally suing you in the name of a crime, and so they're hiding it as a criminal charge when really it's a fucking claim in equity. And if you're not literally operating in commerce at the time of any of these charges, they have nothing there, and they just fucking kind of hide them as like a different name. This is crazy. So the court lacks subject matter jurisdiction over the plaintiff's suit, therefore the suit should be abated. I agree with the fucking fact that a suit should be abated there. Especially given the fact that they have no fucking standing to begin with. This is pretty fucking horrendous. Shit is horrendous. So, we'll get into this next slide. Let me just write down these fucking times for these slides, man. This shit is fucking pretty tedious. So let's go. Let's get into this. This court jurisdiction is restricted to cases wherein there has been no deprivation of constitutional rights of the parties. The plaintiff has deprived the defendant of his due process rights. The administrative agency has proceeded without statutory and regulatory authority, and the administrative agency has deprived the defendant of substantive due process rights. The court is deprived of subject matter jurisdiction. And just based on those facts alone, it's absolutely true. And so the Supreme Court is going to really be focusing on the procedural or lack thereof of the due process, right? So procedure is crucial. And you know what's funny is that these fucking fake ass lawyers, they go to school for 4 years studying procedure and case law, right? So at what point did you forget the fucking procedure? proper fucking procedure, standard operating fucking procedure. At what point, out of the 4 years that you went there just to study that, because you guys don't study law, none of you fucking fake ass lawyers study law. How do you fucking forget what the fucking procedure is? You know what I'm saying? Come on, bro. So due process requiring relating to grand jury arrays and indictments. Number 5, defendant now summarizes indispensable and substantive elements of federal criminal prosecution which constitutes applicable due process rights in the instant matter which were not afforded the defendant. The criminal prosecution process may commence if and only if there is an affidavit of criminal complaint under an oath of probable cause hearing. Rule 3 FR Criminal P. So procedure is not being followed at any point, and they hope that you don't know that in order to make a plea, which at that point nullifies all of their errors and criminal acts once you fucking agree to their bullshit. So B, committing magistrate judge must issue a warrant of summons after finding probable cause. That's Rule 4. The defendant may be arrested and returned by the appropriate federal authority. That's Rule 4. The defendant then has an initial appearance at which he is asked to enter a plea and bond, if any, is set. If the offense is a felony offense, the United States magistrate may not ask for or enter a plea. The defendant is entitled to preliminary hearings unless an indictment or information against a corporation is returned prior to a preliminary hearing in the event that the defendant is joined by a grand jury under Rule 8 and has not previously been arrested. The federal criminal prosecution process begins here, and the defendant is entitled to a preliminary hearing. If the defendant exercises his right to a preliminary hearing, he has the opportunity to cross-examine adverse witnesses, and he may introduce his own evidence, whether evidence is via a... Let's see what the fucking next part of this shit is. Is via a what? Via a witness, or is documentary evidence, Rule 5.1. The preliminary examination may be bypassed only in the event that the defendant waives his rights or indictment issues subsequent to the initial appearance in the federal system. Corporations may be prosecuted by information. So the defendant or his counsel has the right to challenge the array of the grand jury pool and void data individual grand jury candidates prior to the grand jury being sworn in, right? And so all these charges have to be brought forward by a fucking grand jury, which, by mind you, it can be a group of whoever the fuck that they say is the grand jury, which is going to be a bunch of weirdos, and they can fucking indict a goddamn cheeseburger if they really want to, right? Because those are all usually held in private, secret fucking grand jury meetings that what the fuck even happens in there. You know what I'm saying? They probably just smoke weed and fucking laugh about who the fuck they're going to charge next, because these motherfuckers are not going by law. So in the course of its investigation, based on an affidavit of complaint and finding the probable cause, a grand jury may by presentment issue additional indictments and or join additional defendants in compliance with provisions of Rule 8. The grand jury must return and so why is it that the cops never there, right? You always got these third-party fucking collection agencies, which is the judge, the fucking prosecutor, and the corny ass lawyer standing there. These motherfuckers had nothing to do with this shit. You don't even know these motherfuckers. What the fuck are you going there answering these stupid ass motherfuckers questions for? Were they even there? They're not fucking first-hand witnesses at all. They have nothing to do with the action at all. The fucking main person that supposedly made the fucking claim, which is going to be some stupid ass asshole on the side of the road that has no business even talking to you to begin with, created some fucking charge out of fucking thin air, a debt, and then these motherfuckers are going to try to fucking tag team you in the fucking courtroom and try to get at your fucking estate. Bro, get the fuck out of here with that shit. Get the fuck out of here with that shit. So the grand jury must return indictments in open court, and the grand jury foreman must file a letter, a certificate of concurrence with the clerk of courts, meaning that they have to fucking agree with them, right? So a warrant of summons may issue against additional parties joined to an original cause of action subsequent to grand jury deliberation and return of indictment in accordance with Rule 6. After all previous conditions are met, as applicable, a defendant may be arraigned and called on to plead, as Rule 10 there. So the conclusion, defendants now make this timely notice to abate under authority 28 U.S.C. 1867E. Pursuant to Rule 6B for the Federal Rules of Criminal Procedure, defendant must be notified of a grand jury investigation. In the instant matter, defendant was not notified of any grand jury being seated and while he was the target of the investigation. Therefore, defendant did not have the opportunity to challenge the jury pool and individual jurors seated on the grand jury as required by law. So they're not even allowed to just go in the to go anywhere and start fucking charging people with shit unless you take part in the grand jury and have a opportunity to question all of these clowns in the grand jury that you don't even know. You don't even know these motherfuckers, bro. The fuck are they even in the room talking about you for? You don't even know them. Get the fuck out of here with that dumb shit. So here you just get the last slide. It's talking. So this will be the bottom part of your affidavit there. Just put your name there. Defendant in error, because it is a fucking error. It is an error. All right. Unless you can prove otherwise. So this will be the next affidavit. So, and this is all district court, federal rule shit. So when you get your estoppel in, promissory estoppel, which is a service that I offer, which is a contract, you know, this is going to give you claims in equity and private, and you're going to send this to the Supreme Court justices as well, which is going to make any issues that you have an immediate matter for the Supreme Court, which you can drag all these fucking retards in there with you, because you're going to have a contract with the Supreme Court justice in your state. So any problems that you have, then at that point, you're going to be able to go ahead and get any of these stupid ass clowns that work for the state or the city or all that, and go ahead and drag them right into the fucking Supreme Court and rock their motherfucking world with this shit. Because it's all about contracts, and you need to do equity. You need to have contracts in order to fucking enforce any of your private rights. They need to be in the form of a contract. So anybody that has a better fucking idea about dealing with all this shit, let me know. Matter of fact, don't let me know, because the comments off. I don't give a fuck what really nobody's talking about, because everybody got a lot to say and nobody actually knows what the fuck that they're talking about. So contracts are the only way. So here, defendant's memorandum of law in support of notice to abate for lack of subject matter jurisdiction. The only legitimate procedure for the government to get around proper process as prescribed in Rules 3 through 11 is if someone is joined to an existing investigation in accordance with Rule 8. In other words, there must be an affidavit of complaint against someone as required by Rule 3, then the process followed through Rule 5 and usually Rule 5.1 prior to a grand jury being selected and seated for that particular case. Thereafter, related offenses can be added and new defendants named in accordance with Rule 8. Then only then does Rule 9 warrant apply. So, and you got these people fucking using administrative fucking tactics to try to default people into getting warrants, to create a debt out of fucking thin air magically, to be able to try to gain access to their fucking estate, right? By creating a fucking fake ass debt. Ooh, now they have access to your account. Now they're gonna do some fraudulent bullshit on the back end and start filling up their fucking private trust accounts with it, right? This is what they're doing. So the defendant understands that a 28 USC 2072 Federal Rules of Procedure may not deprive any substantive rights. Poetically speaking, rights secured by the 4th, 5th, and 6th and 9th Amendments are carved into stone, and defendant further suggests that they are cumulative. So number 3, rights are not independent of elective unless someone knowingly chooses to forfeit one of the specified rights. If one of the constitutionally secured rights is bypassed, the administrative offices here we go. The administrative offices, including the Department of Justice, U.S. Attorney, and the courts of the United States, lack or lose subject matter jurisdiction. This is the essence of the 5th Amendment, guarantee that no person shall be deprived of life, liberty, and property without due process of law. And your rights are your property too as well, so keep that in mind. So not only does there have to be law which compels or prohibits any given activity, the law is usually complex, involving more than one statute, but procedure or process must conform to that prescribed by the Constitution of the laws of the United States. The 4th, 5th, 6th, and 9th Amendments secure mandatory minimum requirements of due process. So the Fourth Amendment requires for probable cause supported by an oath or affirmation is the demarcation point. No warrant shall issue but upon probable cause supported by oath or affirmation. There must be one oath or affirmation, complaint that sets out the key elements of a crime, and 3, committing magistrate must issue a warrant based on complaint. Unless or until these 3 threshold requirements are met, there can be no federal prosecution. Defendant, for illustration, will use federal tax law as an example. At 18 U.S.C. Clause 3045, we find authorization for who may set the criminal prosecution process in motion via an affidavit of complaint. Warrants or arrests for violations of internal revenue laws may be issued by United States magistrates upon the complaint of a United States attorney, assistant United States attorney, collector or deputy collector of internal revenue or revenue agent or private citizen, but no such warrant of arrest shall be issued upon the complaint of a private citizen unless first approved in writing by United States attorney, and which you can get in contact with them as well. Keep in mind, you know, a lot of these people are not your enemy. They would like to have you believe that they are, but you can call the Supreme Court clerks and all that shit. They're extremely fucking helpful with getting any of the shit done that you need to get done. You don't have to rely on fucking random ass people on the internet and shit like that to get your information. You can very well call any of these fucking Supreme Court clerks and they will fucking guide you with whatever the fuck you need. They're really, really helpful people. Keep that in mind. So 8, this code section needs an amount of qualifications. Whoever makes the affidavit of complaint must have personal knowledge of the facts. In other words, the U.S. attorney cannot make the affidavit of complaint unless he has personally been involved with the investigation process, has hands-on involvement with securing an examination of evidence. And that's the thing. You got all these people out here fucking making these crazy-ass claims, and none of these motherfuckers were there, right? You have any first-hand witnesses in any of these motherfucking actions? I doubt it. Highly, highly doubt it. Alright? So, and that's a problem. That's a big fucking problem. Bunch of fucking hearsay. So, defendant's question then is whether or not the federal rules of criminal procedure preserve this constitutionally secured right. We find that they do. Rule 3 of the FR criminal P procedure is specific. Rule number 3, the complaint. The complaint is a written statement of the essential facts constituting the offense charged. It shall be made upon oath before a magistrate judge. So all these people got to be testifying under the penalty. You know what I'm saying? They just throw a lot of claims out there. Nobody's signing these shits. They're hoping that you don't catch it and just go along with the bullshit. Make this motherfucker sign under the penalty, bro. Put your motherfucking money where your mouth is. Put your ass on the line too. You know what I'm saying? So Rule 3 through 9 of the Federal Rules of Criminal Procedure preserve the proper procedural sequence of the 4th, 5th, and 6th Amendment. If any portion of these rules or any of the 3 amendments is defective, courts of the United States lose subject matter jurisdiction, which means that they have to follow the fucking rules to the game. Alright? So, why would there be rules to the game if there was nobody to make sure that you were fucking following the rules? You need to be the one making sure that these dickheads are following the rules. So 10, in our presentment environment, the first most people know a federal investigation is when they receive a summons in the mail with something akin to an indictment attached to it, or they are arrested on a warrant with an indictment attached. Occasionally, a U.S. attorney, the criminal division of the Internal Revenue Service, which is my favorite office too. Criminal Investigation Division of the IRS, great fucking people. They get shit popping. For real, they do. So the FBI or another federal agency will notify the target of an investigation, and sometimes the target will be afforded the opportunity to testify a grand jury that may be considered an indictment. Defendant was never notified, right? Just like me. They sent me a fucking some shit in the mail to an address that I don't even live at, because I would never give these motherfuckers my address at all, ever, under any circumstances, unless they give me their fucking personal home address. You're not getting mine. So they'll send it to some random ass address, try to default you in, and how the fuck does that work, bro? What the fuck part of the game is that? The fuck out of here. So whether arrest or summon, the target's first court appearance is at the alleged arraignment after the grand jury has supposedly issued an indictment. At the hearing, the defendant is asked to enter a plea. If the defendant refuses to enter a plea, the presiding magistrate, usually a United States magistrate judge, enters a plea for him. After that ritual, the United States magistrate judge will either set bond or deny bond. Well, they can't fucking practice law while they're on the bench, so they cannot enter a plea for you. So how the fuck does that work? It doesn't work. I'll tell you that right now. So where is the affidavit of complaint, probable cause hearing, etc.? Has the defendant had the opportunity to examine witnesses and evidence against him, call his own witnesses, and present contravening documentary or other evidence? As we will see, the current federal prosecution practice for all practical purposes thrashes forth Fifth and Sixth Amendment and Ninth due process rights, and it employs the service of quasi-judicial officers who don't have lawful authority to do what they're doing. Right? At all. Motherfuckers are not even authorized. So, you know, they're hoping that you don't know that, though. That's what the fuck's going on. Hoping that you don't know that. Hoping that they don't catch that. So, federal prosecution practice amounts to criminal conspiracy among administrative and judicial officers. Federal criminal prosecution must begin with the affidavit of criminal complaint required by the 4th Amendment and Rule 3 of the Federal Rules of Criminal Procedure. Without the affidavit of complaint, courts of the United States do not have subject matter jurisdiction. So whatever ensuing verdict, judgment, and or sentence there might be is a nullity. It is void, and for this reason alone, the action should be vacated. All right. So this is why you go to the Court of fucking Appeals and all that. Even if, you know, sometimes, you know, they make errors and shit. So you go to the Court of fucking Appeals and all that. They're gonna strictly rule based on fucking procedural defects or issues thereof, which a lot of the times there is, and you get everything vacated based on procedural defects. So we then go to Rule 4, the probable cause hearing. Warrants for seizure and or arrest must issue following a probable cause hearing. The federal courts are presently relying on Rule 9A, warrant or summons upon indictment or information. Rule number 9A in relative part stipulates that this: upon the request of the attorney for the government, the court shall issue a warrant for each defendant named in that information, which is another name for an affidavit, supported by a showing of probable cause under the oath as required by Rule 4, or an indictment. More than one warrant or summons may issue for the same defendant. Right, and those are all checks and bills and shit like that they're really fucking hitting you with to access your fucking estate. So when a defendant is arrested with a warrant or given a summons, appears initially before a magistrate judge, you know, magistrate, magi, right, fucking magician, right, the magistrate shall proceed in accordance with the applicable divisions of Rule 5. This is all magic. They're doing black magic on you fucking people, and with all these spells and shit is what it is. You know. You ever think about how they're spelling these words? You ever think about the word spelling? How is it spelled? You ever think about a magic spell? Think about it. The government then jumps to Rule 10. The arraignment, rather than dropping back to Rule 5, as Rule 9 specifies, Rule 5 is initial appearance before the magistrate judge. Grand juries have certain investigative powers. If in the course of investigating a case that is lawfully before them, the grand jury members may find evidence sufficient to recommend additional charges or name additional defendants by way of presentment, right? Presentments, offers. These are all offers. But if the original complaint against the primary defendant for a specific offense is not before it, the grand jury has no basis for initiating any investigation. There must be original probable cause. Let me write down this fucking time slides. Initial for the probable cause determined by a committing magistrate with the finding of probable cause being predicated on the complaint and affidavit. Rule 6b1. To demonstrate this, number 1, challenges. The attorney for the government or a defendant who has been held to answer in the district court may challenge the array of jurors on the ground that the grand jury was not selected, drawn, or summoned in accordance with law, and may challenge an individual juror on the grounds that the juror is not legally qualified. Challenges shall be made before the administration of the oaths to the jurors and shall be tried by the court. 21. The right to challenge grand jury array, composition, and individual jurors is antecedent to individual jurors being administered by the oath required prior to grand jury being formally seated. 22. The government attorney and the defendant of the defendant's counsel both has the right to challenge the array and disqualify grand jury candidates prior to the grand jury being seated. If the right has been denied, there is a simple solution at Rule 6b2, motion to dismiss. A motion to dismiss the indictment may be based on objections to array or on the lack of legal qualifications of an individual juror. If not previously determined upon challenge, it shall be made in the manner prescribed here, 28 U.S.C. Clause 1876C, and shall be granted under conditions prescribed in that statute. An indictment shall not be dismissed on the ground that one or more members of the grand jury were not legally qualified if it appears that the record kept pursuant to subdivision C of this rule that 12 or more jurors, after deducting the number of legally qualified, concurred in finding the indictment. So Rule 6 required the grand jury foreman to record the vote, then file a letter of certificate of concurrence with the clerk of court. 24. If the original defendant or his counsel did not have the opportunity to challenge the grand jury array composition selection process, which you're supposed to be part of, and they're usually doing it in secret, and individual grand jurors prior to the grand jury being seated, they're all disqualified, as the qualification process is among the defendant's constitutionally secured due rights process. So you are supposed to take part in these fucking secret little fucking meetings that they're all having to decide whether or not they're going to be making claims against you. You have a right to take part in all that shit, and if you don't, you can fucking dismiss based on those facts alone. So by consulting Chapter 121 of Title 28 generally and 28 U.S.C. Clause 1867 specifically, we find that there is no distinction in the voir dire examination and other qualification process for grand juries or petit trial juries, which is a small trial that they're having behind your fucking back, right? So in criminal cases, before the voir dire examinations or within 7 days of the defendant discovered or could have discovered by the exercise of diligence the grounds therefore, whichever is earlier, the defendant may move to dismiss the indictment or stay the proceedings against him on the grounds of substantial failure to comply with the provisions of this title in selecting the grand jury petit jury, which is the fucking grand jury shit that they're doing. They're doing a small trial there without you. You know what I'm saying? Bunch of dudes smoking weed, laughing and shit. So if a defendant doesn't know a grand jury is investigating him, he doesn't have the opportunity to challenge the grand jury array or individual grand jurors. Consequently, he has been deprived of substantive due process, which is expressly prohibited in 28 U.S.C. Clause 2072B. Right? We have an adversarial judicial system in this country. All parties to any given action of the government included stand on equal ground. This system isn't set up for the convenience of the government. In fact, government has always had the burden of proof, whether in civil or criminal matters. The defendant has the right to challenge the qualifications and competency of everyone involved in the prosecution process. You know what I'm saying? So they're always here talking about these license to practice law and shit like that. You ever ask them for theirs? They don't have them. They don't fucking exist. I'll tell you that right now. They won't tell you that. I'll tell you that. They don't fucking exist. So inclusive on grand and petite jurors selected from peers who ultimately have the responsibility for determining indictable offenses and or final liability. If when the government personnel deprive the citizen of any of these rights constitutionally secured, due process of law is abridged and the court loses subject matter jurisdiction at that point. Now consider Rule 6. Finding and return of indictment. An indictment may be found only upon concurrence of 12 or more jurors. The indictment shall be returned by the grand jury to a federal magistrate judge in open court. If a complaint or information is pending against the defendant and 12 jurors do not concur in finding an indictment with the foreperson, shall so report to a federal magistrate in writing forthwith. Right? So they literally need 12 fucking people to go ahead and charge you with any of this nonsense. And you have an obligation for them to allow you to take part in that action as well. Right? Because it is your life after all, right? So this section of Rule 6 specifies foundational necessities federal government may prosecute. So felony crimes only on a valid affidavit of complaint that has been presented in a probable cause hearing, Rules 3 and 4. Only corporations can be prosecuted via information. You see that? So this is why they're charging you straw man. They're making you believe it's you, when in all reality they only have the jurisdiction to charge a corporation with via information. So you see how that works, right? In the context of Rule 6, we see that the antecedent affidavit, which is the one that came first, of complaint and probable cause hearing preserved in the second sentence. The grand jury may proceed only on complaint or information that has previously been formally processed. If the grand jury issues an indictment, the return must be made in open court to a magistrate judge. The return should appear on the case docket, and a transcript of the hearing should be available. A return of an indictment is the same. A return of an indictment is the same as the petite jury return of a verdict. In practice, any given grand jury returns several indictments at once. However, when defendant understood the indictment process, it is clear that the grand jury pool may be held over several months, but that any given grand jury is empaneled to consider only one charge or set of charges in the related case. So to date, defendants haven't found where an indictment on any single case or set of related cases has been returned in open court and a transcript of the proceeding is available. So they're doing this shit in secret, essentially, is what this is getting at, which is not lawful. So Rule 8 governs limit of the reach of any given grand jury, being Rule 8, joinder of offenses and of defendants. During any court or jury session, any given juror might sit on one or more grand juries or petite juries, but each jury has limited subject matter jurisdiction. So they're only really allowed to speak on certain issues, topics, and charge you for a certain set of incidences, and then there's a fucking procedure involved with all those matters as well. So these motherfuckers are not just at liberty to do what the fuck that they want. It doesn't work like that. There's rules to the game. Rules to the game. So here, where the grand jury is concerned, it may proceed only from an original complaint where probable cause has been found to issue additional indictments and or additional names, defendants where the crimes are of the same or similar character or are based on the same act or transaction on two or more acts or transactions connected together or constituting parts of a common scheme or plan. Rule 8 and Rule 8A and Rule 8B specifies criteria for naming additional defendants. Here is where defendants' reservation of rights in Rule 9A comes in. When a defendant arrested with a warrant or given a summons appears initially before a magistrate, the magistrate shall proceed in accordance with applicable subdivisions of Rule 5. We will consider Rule 5B and the first portion of Rule 5C. B. Misdemeanors and other petty offenses. If the charge against the defendant is a misdemeanor or other petty offense triable by a United States magistrate judge under 18 U.S.C. Clause 3401, the magistrate shall proceed in accordance with Rule 58. Offenses not triable by the United States magistrate judge. If the charge against the defendant is not triable by the United States magistrate judge, the defendant shall not be called upon so to plead. Right? So if any of their motherfucking charges are not one that are able to be tried by a United States magistrate judge, then they can't even fucking ask you, what do you plead? But they'll love to try to get you to think you have to plead, or the judge will, or the fake fucking judge, the clerk magistrate, will go ahead and enter a plea on your behalf, which is unlawful because they cannot practice law from the bench. But this is what they're doing, entering a plea for you. Yeah, right, bro. So what is known as the United States magistrate judge was originally a national park commissioner. The name of the office has changed, but the nature of the office hasn't. This is an administrative but not a judicial office. It's equivalent to what used to be the police court magistrate. Today, the only offenses triable by a United States magistrate judge are traffic violations and other petty offenses committed on military reservations in national parks and forests under regulations promulgated by the Department of Defense and the Department of the Interior. United States magistrate judge in several states have venue jurisdiction solely over offenses committed on federal enclaves where United States government has exclusive and concurrent jurisdiction coded by one of the several states, right? So they're charging people with shit in areas and parts of the land that they don't even have the fucking jurisdiction over, right? This is what's happening. Hoping that you don't catch it. As Rule 5C specifies, they cannot even ask, much less make a plea for a defendant charged with a felony crime. The prohibition is effective under Rules 5, 9, 10, and 11. So you find a case that any of these assholes enter the plea for you, you can most likely get that shit tossed the fuck out. You know what I'm saying? Because who the fuck are they? Or you can enter a plea for yourself, motherfucker. You're not going to enter a plea for me. You know what I'm saying? Get the fuck out of here with that. So when and if a United States magistrate judge asks for or makes a plea for a defendant in a felony case, he has usurped power vested in Article 3, judicial officers of the United States, where this quasi-judicial officer exceeds authority Congress vested in him by law. The United States loses subject matter jurisdiction, and there are grounds to pursue lawful remedies, both civil and criminal. These motherfuckers have only ever had the power to regulate commerce. That's all that they have the power for. That's why the contracts that I offer, estoppels, are contracts in equity, because you got to do equity to get equity claims. So this is what we do here, right? And it's going to put you right in the jurisdiction of the Supreme Court, and you can drag these dickheads in when they get out of line. Really, really simple concept. So government officials, regardless of capacity, enjoy the cloak of immunity only to the outer reaches of their lawful authority. The notion of blanket judicial or any other absolute immunity, nothing more than a convenient fiction. It's false. It's a fucking lie. They like to make you think that you can't fucking hold them accountable, but you absolutely can. Trust me. So Rule 5, second paragraph also specifies a defendant is entitled to a preliminary examination unless waived when charged with any offense other than a petty offense, which is to be tried by a judge of the district court. It is useful to understand the term magistrate judge as opposed to United States magistrate judge or United States magistrate judge. The president of the United States is the nation's highest magistrate. Magi. Alright? That's what they are. They're fucking magicians. In other words, the magistrate is a ministerial, not a judicial offense. All lawful judges function in a magistrate capacity. I mean, mind you, a fucking notary is a motherfucking magistrate. That's it. So, and you see the qualifications to become a notary. That shit is really fucking vague. So all lawful judges function in a magistrate capacity when they preside at probable cause hearings. Initial appearances and the like, in a sense, this is an extrajudicial capacity that within proper context can be vested in or exercised by an administrative or judicial officer. The United States magistrate judge is an administrative office with quasi-judicial capacity limited to specific subject matter where the district judge of the United States is vested with. All right. Let me write this motherfucker down. A couple more slides here. We're almost done. So, a full range of United States judicial authority, i.e. his extrajudicial capacity as magistrate judge, extends to federal offenses of all stripes. Essentials to the preliminary hearing of examination are prescribed at Rule 5.1a of the Federal Rules of Criminal Procedure. Probable cause finding: if from the evidence it appears that there is a probable cause to believe that an offense has been committed and that the defendant committed it, the federal judge magistrate shall forthwith hold the defendant to answer in district court. The finding of probable cause may be based upon hearsay. Of course, it'll be based upon hearsay evidence, in whole or in part. The defendant may cross-examine adverse witnesses and may introduce evidence. Now we go back to Rule 5C, second paragraph. A defendant is entitled to a preliminary examination unless waived when charged with any offense other than a petty offense, which is to be tried by a judge of the district court. If the defendant waives preliminary examination, the magistrate judge shall forthwith hold the defendant to answer in the district court. If the defendant does not waive the preliminary examination, the magistrate shall schedule a preliminary examination. Such examination shall be held with a reasonable time, in any event not later than 10 days following the initial appearance. If the defendant is in custody, and no later than 20 days. If the defendant is not in custody, provided, however, that the preliminary examination shall not be held if the defendant is indicted or if an information against the defendant is filed in district court before the date set for the preliminary examination. If a defendant is joined to an indictment under Rule 8, he has the right to a preliminary hearing under Rule 5.1. This assures his opportunity to challenge the witness and present evidence before being subject to the trial process. The right is particularly important when government prosecutors routinely play let's make a deal to secure incriminating testimony from questionable witnesses, right? So which is a good reason to lie, right? When they fucking bag somebody with a fucking dime bag and they're telling them, oh, you're gonna get fucking 30 years, but let's make a deal. Let's have you fucking make up a story about such and such, right? This is what they do. So it appears that the Department of Justice and United States attorneys are convening grand juries under auspices and the special grand jury provisions under Chapter 216 of Title 18. However, this is misapplication of law, as special grand jury investigations authority extends only to criminal activity involving government personnel, and the grand jury is limited to issuing what? get this motherfucking slide over her. Two more slides, guys, and we're all done. All right. Or 4 more. I lied. 4 more. So here, reports, defendants, and the prospective defendants are afforded the opportunity to rebut or correct the reports prior to public release. Although evidence unearthed by special grand jury may be used as the basis of criminal prosecution, the special grand jury does not have indictment authority. It appears that the first steps towards securing secret indictments were taken during Prohibition days to shield grand jury members from organized crime reprisal. Although secret indictments were and are patently unconstitutional, the extreme remedy of the midst of high volatile and dangerous circumstances was rationalized in the midst of what amounted to domestic war with organized crime. Unfortunately, as other rationalizations, those who found the extraordinary process is convenient incorporated it as routine practice, right? So they found that, yeah, that nobody was really arguing with them to question the procedural procedural defects that are involved with a, what do you call it, a secret fucking indictment, right, which completely violates your constitutional rights. So they found that nobody was questioning them, and so they just kept on, and they made it a routine practice. So Rule 60 of the Federal Rules of Civil Procedure preserves cause to challenge judgments. They are as follows: mistake, inadvertent surprise, or excusable neglect; newly discovered evidence which by due diligence could not have been discovered in time to move for a new trial under Rule 59; fraud, whether hereto denominated intrinsic or extrinsic misrepresentations or other misconducts of an adverse party. The judgment is void. The judgment has been satisfied, released, or discharged, or a prior judgment upon which it is based, reversed, or otherwise vacated, or it is no longer equitable for that judgment should have prospective application. Any other reason justifying relief from the operation of the judgment. The rule then specifies, and we'll see what this thing's talking about. So the rule then specifies that the motion shall be made within a reasonable time and for reasons 1, 2, and 3, not more than 1 year after the judgment order or proceeding was entered or taken. A motion under this subdivision does not affect the finality of a judgment or suspend its operation. This rule does not limit the power of the court to entertain or an independent action or relieve a party from a judgment, order, or proceeding, or to grant relief to a defendant not actually personally notified as provided in Title 28 U.S.C. Clause 1655, or to set aside a judgment for fraud upon the court. Writs of corpus nobis bills in the nature of a bill of review are abolished, and the procedure for obtaining any relief from a judgment shall be by motion as prescribed by the rules or by an independent action. There are 2 keys in Rule 60. First rule, 60B, where the judgment is void, opens the door to vacating a judgment at any time. At second, the void judgment may be attacked by motion or prescribed in these rules or by an independent action. A judgment is void where the court lacks subject matter jurisdiction. The court lacks subject matter jurisdiction when and if the administrative agency has proceeded without statutory and regulatory authority, or the administrative agency has deprived the defendant of substantive due process rights. Right? So where the court lacks subject matter jurisdiction, the judgment is void. It has no lawful effect. The defendant may proceed by motion at any time without the encumbrance of time limitation. If you can point out that there has been a defect, it doesn't matter, there is no statute of limitations, you can go ahead and get all that shit waived. Or may initiate collateral attack via extraordinary writs or an independent action. Respectfully submitted. It'll be your name, defendant in error, right? That's what you would be, defendant in error. Because it never should have taken place. It should have never taken place. So that's what we got. It is a game of chess. Stop playing checkers with these fucking assholes. That's what I got for you for now. Until we meet again.